This is WPSL Port St. Lucie, the talk of the Treasure Coast.
On your radio at AM 1590, on the web, plus Google Home and Alexa. Ask for us by name, WPSL Digital 1590. The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Ask a Lawyer, and if you are within the reach of my voice, call us at 772-340-1590.
And if you live on this planet, you're within reach of your voice.
That's true, and I can't hear anything through here. Technical difficulties, but I'll keep on moving. Anyway, give us a call about any questions you may have. Doesn't matter whether it's on our topic or not. I just pick a topic and we move, and feel free to call us, and anything that's on your mind, that's really what we're here for. Anyway, so last week we seem to have created a little bit of a stir talking about transgender rights. Indeed, it seems as if I may have co-opted the rabbi show because she came in and had to talk about it as well. Whoops, I am changing headsets. Let's see. Is it plugged in? It is plugged in, but I don't hear a thing. I heard stuff before, so you must have pressed a button. And now my thing has fallen. Okay. Hey, what can I tell you? This is radio, folks. This is live. You know, on the first night of that Democratic National Debate in Miami on Thursday, well, today's Thursday, on Wednesday, they had so many technical difficulties. Control room, please turn off the mics. This is what happens on live radio and TV. You know, I don't know. Maybe I could hear a little bit. We'll manage. We'll see what happens when a call comes in. Or maybe it's just my imagination that I can't hear. Okay. So interestingly, we were talking about transgender rights last Friday. And sure enough, on Wednesday night in the Democratic presidential debate round one, it came up there too. And the only thing I'll really say about that is it is an indicator that it is becoming an issue within society, an issue significant enough, an issue of enough social discussion to have warranted comment on the presidential debate stage. And that is one step closer to a full societal discussion about the issue, and then a determination of legislative rights, or just rights that are going to be granted or rights that are inherent. So I actually found that interesting to hear the brief discussion that was made on Wednesday night. Now, last night, transgender rights in particular did not come up, but LGBTQ came up. Again, an indicator that these are topics that are becoming part of the national discussion. And that is a first step towards a society as a whole deciding where it is in terms of something relatively new to legislation or constitutional law. And now we do have two calls waiting for us, so we will start with number one. We have Bill on line one. Hey, Bill, how can I help you?
Yeah, I sold a house to one of these repay cash people.
Okay.
You know what I'm saying, right?
Yes,
There's hundreds of
all
them.
those little signs, we pay cash for houses.
Yeah. All right, well, I sold one to one of them, and it's supposed to be they pay all closing costs, they pay everything, and it's all in the contract that they do that. But you have to sign the house away a day or two before you get your money.
Well, that's not uncommon. It's not that the house actually leaves once you sign it. Monies are held in escrow, and until monies are released, you haven't actually released title of your property.
Well, my problem is they didn't go by the contract. They gypped me out of about $3,000.
Then
They charged me closing costs and crap at the.
All right. Well, then
table.
the first step would be to send them a letter outlining what it was that they charged you for closing costs that should not have been charged pursuant to the contract that you entered into.
Your next step is to call Stewart.
The next step, if your own letter does not work, then the next step is to call an attorney. Because it sounds like a breach of contract, and I dare guess that contract has an attorney's fees provision which provides that the prevailing party gets to recover their attorney's fees.
Yeah, well, I sent the registered mail return receipt to the closing agency and came back undeliverable.
All right, well, maybe there was a mistake in the address.
The address is right off the closing statement.
I know, that doesn't mean it's correct. It could have been a mistake in the address on the closing statement. I would just Google the name of the company.
They had 3 different closing statements, every one different.
I would Google the name.
Not different address, but different amounts.
I would Google the name of the company, and I'm sure you can find an address of the company, and send them a certified letter return receipt.
Would you be interested in handling it?
Well, actually, it's not cost effective to you. That's why I always recommend that people do this first on their own. Because you're talking a few $1,000s to come into my office honestly and meet with me and go over the documents and have me write a letter. You're going to be charged at least $1,000. And while I'm happy to take your money, I don't necessarily want to take your money if you can write a letter and achieve the same success without me.
They refused to deal with me.
Well, but you just said the letter came back undeliverable.
Yeah, but I've met with the one that since I'm in Delaware most of the time. I'm just down here a short time.
Okay.
And I met with the woman that actually bought the house, and
forget the woman who bought the house. She has nothing to do with this. Well, and you mean the company that says we pay cash for houses, right?
Yeah.
All right, don't talk to her on the phone. That never gets anywhere. I can't tell you how many times we tell people who call our office, put it in writing. You send a letter to an address that will work. See what happens. If it doesn't help you, then feel free to give my office a call, and we'll see, if we can help you. I just hate to start out that way because you may be paying me money that you don't need to pay me.
But if you took the case and won it, the lawyer fee they have to pay.
Well, that's if you go all the way to trial 2 years from now. Okay, and you're going to be paying me hourly to do that, and you may be paying me $30,000 to go after $3,000, and yeah, you may get your money back at the end, but I never tell any prospective client to count on that. More than 90% of all cases settle. When cases settle, are attorney's fees recovered? Sometimes in part, but never in full, because that's only going to happen if you win in front of a judge or a jury.
Okay, thank you. Appreciate the information.
All right, good luck, and if it doesn't work, feel free to give us a call. All right, thank you very much. I think we have Mary on line 3.
Well, she's gone.
Mary, if you're listening and you want to call back, feel free to call back. We'll try to get you on right away. Sounds like somebody is there. I'm hearing like a closing of a door, a squeak. Is this like Friday the 13th?
It's Friday the 13th, all right.
All right. Well, maybe it's my imagination. All right. So we were talking about, the political debates and the fact that transgender and LGBTQ rights were both mentioned, one on Wednesday, one on Thursday, and that these are becoming clearly topics of national discussion. So let's sort of finish, if we can, the discussion which I started regarding transgender rights and where they emanate from, and what to do if you have a problem. We were really talking for the most part about Title IX of the Civil Rights Act, which deals with schools and predominantly equality in athletics, but not solely equality in athletics. And then we had also talked a little bit briefly about Title VII, which is in the employment context, and we may go back to that a little bit as well. It's not exactly sexual orientation, but it's a cousin to sexual orientation. So, in addition to Title IX and Title VII, a lot of states will have their own laws with regard to transgender rights. You should always be checking out whether there's a state law. Very often, state laws will give you more rights than the federal government will give you. In fact, in the employment context, that is why we file both under the federal statute, Title VII of the Civil Rights Act, and under the Florida Civil Rights Act, because the remedies in both statutes are slightly different. And if you file under both statutes and you get to a jury, the jury questionnaire will have the relief that's provided under both statutes. So that's a
Isn't
benefit.
that where marijuana is now? I mean, you've got some states that...
That is true, too. Now, things that are clearly a federal issue, states are still free to give you more protection than the federal government gives you. They can't give you less. If the federal government has supremacy on an issue, you can still give more rights as a state. Marijuana is not yet exactly a federal preemption issue. Federal government has...
But they don't allow those stores in Colorado to even have a bank account.
Exactly. It's a cash business.
Gosh.
This is where a number of states are giving much greater rights with regard to marijuana dispensation than the federal government does. And the unique problem here is when the federal government says something is illegal, well, then state banks are hesitant to allow you to have bank accounts and to exchange money and currency. So even though the state, for example, Colorado, is giving you greater rights and access and maybe even decriminalizing marijuana, you may not be able to fully utilize the instruments of interstate commerce, because then the federal government stands with its big wall, not the one that Trump is trying to build, a proverbial wall, and creating havoc for you in terms of your ability to conduct business that affects interstate commerce. But the general guiding principle is that in any law, in any area, a state can give you more protection than a federal government can. If the federal government is giving more protection, the state cannot give less. For example, I don't know if I should even touch this, but Roe versus Wade. A state cannot...
What's that? Oh.
Yeah. A state cannot provide less protection to a woman's right to choose than has been established under Roe versus Wade. So, you all say, why do I keep hearing about all these states that are passing restrictive legislation?
Good question.
That's because they know it's unconstitutional at present, and they are trying to get one of those cases to the Supreme Court in the hopes that either Roe versus Wade will be overruled, given the current composition of the court, or that it will be narrowed, and the narrowing is sometimes the first step to completely overruling.
Isn't Roe v. Wade a law, though?
Roe v. Wade is not a law. It's a constitutional right established by the Supreme Court under the 14th Amendment and the right of privacy. So it's applicable to the states under the 14th Amendment. Okay. But it's a right to privacy law. And Congress has passed a number of statutes. Some of them have been ruled unconstitutional. And some of them are fine because they're consistent with the dictates of Roe versus Wade. But even Congress cannot pass a statute that is unconstitutional. And I would have said, until a couple of years ago, the president cannot act in a manner which is unconstitutional. Now, it may still be that
we've never had a president
that will come to pass. Remember, even in good old early 70s, Nixon fought and fought and fought, but when the Supreme Court said hand over those tapes, he at least accepted the rule of law. The Supreme Court spoke, he handed them over, and very soon thereafter, he resigned the presidency. That is the whole argument why you keep hearing over the last several years the rule of law. This is a nation that is governed by the rule of law. We may not always like it. We may not always agree with it. But it is what keeps us from becoming animals. And in fact, it's very interesting. Oh, here's a good old deviation. I just love deviations. My son, who is going to be engaged in Lincoln Douglas debating beginning the next school year and is leaving this Saturday, tomorrow, to go to debate camp.
Very cool.
Yes,
Very cool.
yes.
How long is the camp?
It's 2 weeks, and I'm very excited to have 2 weeks without him. And he's very excited, I think, to get away from me. So, hey, it's even.
So this is down at Nova, right?
This is down at Nova in Davie, yes.
Very cool.
He
He'll love the campus.
He has a
It's
dorm, a three-person dorm room.
Very cool.
And I found all the eating places he likes are all the way on the other side of campus. He's going to have a lot of walking to do. But then again, in those days, I could do that walk too. So, maybe he'll do it.
It's a beautiful campus. Beautiful campus.
But the interesting thing is, for Lincoln Douglas debating, the topic changes every 2 to 3 months. The first topic for the next school year, and I'm not going to get this sentence exactly right, but the gist will be right, is that civil disobedience is morally justified in a democratic society. So the affirmative argues that, yes, civil disobedience is okay within a democracy, even though you're breaking the law. And the negative will argue absolutely not. And, my son and I, in discussing this issue, and discussing, me trying to coach him a little bit, use some of my experience, in debate and as a debate coach, I always tell him, don't take any absolute positions. It's never always or never. See, I just said never. I shouldn't have done that.
There you go.
It's usually never, always, or never.
Oh, come on.
It's always shades of gray. Because once you say always, the other side is going to come at you with that one extreme exception, and you have to concede it. And conceding it makes your overall point weaker. Whereas if you came at the principle with, for the most part, now the other side can't just bring up some outrageous exception, which anybody would agree with, and take away from the value of your point, because you had already conceded, for the most part, this is the principle. And that is really law, folks. Law is not black and white. It rarely is. It is mostly gray. So, my son and I were discussing, well, if you're on the affirmative, you're in favor of this resolution that civil disobedience is morally permissible in a democratic society. Well, how do you argue that? And of course, the first thing he told me was he came up with something from the civil rights movement, and he's always. So I wait till he's done and I cross-examine him. And he doesn't know what to say. And ultimately, I force him to concede the point. And, use it as a teaching lesson. You can't go at it always. And the interesting thing is, again, deviation is fun, I don't mind. But the civil rights movement is an excellent illustration for this point. Martin Luther King Jr. believed in nonviolent civil disobedience as a way of advancing the rights of African Americans. He was good friends with Malcolm X. Malcolm X did not agree with nonviolent civil disobedience. He believed that the only way to effect change was with violent civil disobedience. So they broke, and they both had their own separate groups, let's say, for lack of a better movement. Movements is a better word. Now, I said to my son, we always hear about Martin Luther King Jr. It's a day that's celebrated. Malcolm X Day isn't celebrated. But do you think Martin Luther King Jr. could have achieved the advancement in rights that was achieved if he had been just engaged in nonviolent civil disobedience alone? And he thinks about it a little bit, and he says, no. I said, well, why not? Because not everybody would have listened. Well, how did anybody get anybody to listen? Well, Malcolm X made them listen.
Got their attention.
So the combination in that situation of nonviolent civil disobedience and violent civil disobedience affected change. In some ways, to a lesser extent, so did the equal rights movement for women, which got them into the workforce. Not at 100 cents on the dollar, but it got them, it got working to be a commonplace thing for a woman, not, oh, why aren't you a housewife? It's everybody works now for the most part. And if you choose to be a housewife, shouldn't be looked down on that for either.
It's a very important job.
Okay? But it's usually the combination. So what happens then if you're going to be, let's say, the affirmative in this resolution, and you are conceding that even violent civil disobedience is okay? Man, oh man, the negative is going to come after you like a ton of bricks. So how do you make that argument? Well, first of all, you don't advocate this extreme violent civil disobedience from the beginning. You know, as I've sort of discussed with my son, and it works in other areas, not just this. First, you try to work through the system. Get parade permits. If they're denied, well, you may have to go to another step. You work through the system as best you can. Lawsuits. When the system fails you in a democracy, now you may want to try nonviolent civil disobedience. Many, many times in our country's history. And when that is not really working, you may need to go to some violent civil disobedience. Now, what does violent mean? Do we go kill everybody? No, it doesn't. And here's a kicker, folks. And I told my son, I dare say nobody will have this for the first 2 months of Lincoln Douglas debating unless they all hear my radio show. We researched the Magna Carta. I think it's 1625. Article 91 of the Magna Carta dealt with what happens if you have a grievance against the king. Well, what Article 91 said is you take your grievance to one of 25 barons. That baron takes it to the overall group of 25 barons to rule upon. If they don't rule upon it within 40 days, it is presented to the king. If the king doesn't rule upon it within 40 days, oh my gosh, do you know what the Magna Carta says? You are free to engage in any action whatsoever, including against the king and his family, except killing. You can seize the king's lands. Can't be put into jail for it. You could kidnap the king's kids. It's okay under the Magna Carta.
Wow.
But once the king acts, even if he acts against you, once he acts, you are required to cease and become, this is what it says, a loyal subject to the crown again. So you are permitted to be disloyal if the barons have failed you and the king has failed you. And there is a whole mechanism in Article 91 of the Magna Carta from 1625 that lays it out very clearly. So in discussing this with my son, I said, so wait a second. The Magna Carta provides for violent civil disobedience way back in 1625. So it's hard to say then that under no circumstances should violent civil disobedience be completely untenable in a democratic society. It's not the first choice, and perhaps I agree it should be the very last choice. But it goes back, folks, over 300 years to jolly old England, and that's where our common law comes from. And our Constitution and our Declaration of Independence, in many ways, follows the Magna Carta. So it's hard to say that Malcolm X was doing, even though it was quote-unquote illegal, was not morally permissible. in a democratic society. Okay, so we have Ron on line 1. Hello, Ron. How can I help you?
Hey, morning, Mr. Griff. Mr. Stewart.
Hey.
I was thinking, getting under my skin is, how come the kids are being treated like they do, and if we did it, in the United States, they'd put us in jail.
Okay, now, how come which kids are being treated in what way?
At the border.
Oh, at the border. Oh, gosh.
Yeah.
Okay, well, yeah, I did say
Another can of worms open.
All questions are game, and I do. I love constitutional law. I practice it in the employment and civil rights context, but not all the amendments. But I will tell you, I guess, my opinion, just based upon 33 years of practicing law. I completely agree with you. This is an embarrassment. It is humiliating that the United States can speak to nations throughout the world about their lack of civil rights towards their citizens and other people, and that we could be treating people who cross the border, even if it's unlawfully, in such a abhorrent manner that I do believe it is below the standard of basic human rights and human dignity.
Yeah, because they're human just like anybody else.
And that's right. And maybe in the end they do get sent back. I'm not saying that everybody that crosses should be staying here. Maybe they do get sent back. But, our nation is under due process of law. And that means everybody is entitled to due process of law. And that's what the Constitution says, citizen or non-citizen. Once you're here and you invoke our courts, you're entitled to due process of law under the 14th Amendment. And the idea that there are children, I don't even like the word. I know it's true, and I know why some of the politicians use the word. I don't even like the word cages. There are children that are behind wire bars. Now,
yeah, that's what I've been hearing.
Yeah, if somebody wants to call it a cage, I understand, and maybe it's accurate. I don't want to use that's such a emotionally and sedentary term, for this purpose at least. They're in cages. I just said it. See, now you know where I really stand. They're in wire enclosures. But the biggest thing to me is not only that, but they are separated from their families. There was a court order last year for the Justice Department, for Homeland Security, for Customs and Border Enforcement to fix this. Still, thousands of kids are without their parents. Government doesn't know where their parents are. That is a crime. It is a crime.
Right. But they separated from their families.
Right. And if it wasn't a government, this point was made on the debate last night, actually. If it wasn't a government that did it, there'd be lawsuits and there'd be criminal prosecutions. And somebody on the stage last night called it kidnapping. I'm not so sure I disagree.
In a roundabout way.
And then we hear from credible people, not people on the fringe, credible people, that these children are being denied toothbrushes, toothpaste, access to showers, 3 meals a day, diapers. Women are being denied sanitary products. That, my friend, is not what this nation was built upon. That is something that if it were happening in another country, we would be all over them about the denial of civil rights. Yet it is happening here. I can't believe it.
It's true. It is true.
So I appreciate your question. I tend to agree with you.
All right.
And, call us again.
All right.
Yeah.
Thank you.
Thank you for calling. And I'll sort of finish on that issue by saying there are ways, of course, of taking the government to court, and that is happening. It's a slow process. Judicial is a slow process. Now, you may get some quick injunctions, but the overall resolution is slow. Why anybody would, with the problem having been made so public, continue to deny toothbrush, toothpaste, showers, sanitary products. I can come up with a whole bunch of other items. even prisoners in our jails get these things. Why not these folk, especially the kids?
What came out, I forget whether it was last night or the night before, was that some of these facilities are private.
Well, yes, and that is the problem. My goodness. I get civil rights cases like this a lot, too. A lot of our jails are run privately for profit. The Department of Corrections...
How do you have a for-profit
when
jail?
The governmental entity, whether it's the federal government or the state government, farms out, contracts out to a private institution the security issue? And they're a for-profit company. So, they're supposed to follow the standards that are established, blah, 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 blah. But, their concern predominantly is making a buck. And I don't know how to say this, but jails should not be operated for profit. If we're going to hold somebody and incarcerate them, as bad as it is, it should be run by the government, which supposedly at least has, I won't say their best interests at heart, but is at least supposed to follow constitutional minimums. And I think that the for-profit private jails will skirt the other way as often as they can get away with. Now, that's not to say that, okay, somebody may call and say, I know this for-profit institution that really has an exceptional rating, sure, there may be one or two. Again, we don't deal with absolutes, do we? But for the most part, I think it is abhorrent that we allow private for-profit entities to run jails, whether they're jails for people that are convicted of state or federal offenses, or whether they're on the border. We need to be ensuring that somebody is looking out after minimum basic human rights and minimum human dignity. And I don't know, if you think I should have been on that presidential stage last night, call me. But I'm not running. I can't run very far. Otherwise, maybe there were 22 of them. Maybe I would join the pack. But yes, I agree with that.
Well, there's only about 3 or 4 series, so.
I don't know about 3 or 4. I might go to 5 or 6. There were a lot of them that didn't belong there, but they'll be shaken out relatively quickly
By the next debate.
I mean, and I don't pretend to have a monopoly on which ones they are, but I would say, off the top of my head, Biden and Sanders, Warren and Harris, and
Tulsi Gabbard on night 1.
Well, she sounded good, but I don't think she has the experience. But that's my opinion.
Mm-hmm.
That's why we do this.
Okay.
I don't think the mayors have the experience. Some of them sounded good. New York Mayor de Blasio on Wednesday night, who I've never liked, he was the first one to interrupt, and boy, he did a good job at it and made some good points. I think it may be the first time I heard him speak where I agreed with him. But no, I don't believe he's a serious candidate for president. I think it'll shake out, to the top 5 or so, 6 pretty soon. Especially, if not before, after the first primary. After Iowa, which is a caucus, and after New Hampshire, which is the first primary. Then you get to South Carolina. After South Carolina, I don't think there'll be more than 5 candidates running.
What was interesting was the AP poll, that they had talked about Gabbard the first night, and then last night how Biden was taking a beating from Kamala, and but AP still has Biden in Iowa. This is a poll just in Iowa that was light years ahead of everybody.
But I listened to most of the debate last night. I had to go to the bathroom every so often, or get a chocolate bar.
Get a chocolate bar.
But I don't think Biden did poorly. I don't. I think he did well. Did he do as well as he could have? No. Nor do I think at this point he really has to. He responded to Kamala Harris's attacks. She very strategically, and I agree with her as far as a strategy, chose to come out after him to show that she could take on the front runner. I think for the most part she did it very effectively and eloquently. Sometimes I thought she was a little bit over the edge and...
She's a prosecutor.
Yeah, obnoxious, but then again, prosecutors are often obnoxious. Others would say, I'm saying obnoxious because she's a woman, and I wouldn't say that if it were a man. Trust me, for me, it makes no difference. Sometimes I think she went a little bit too far. I thought Biden could have been a little bit more forceful, but I think Biden's strategy was to stay, at least for now, understated, respond, but not get emotional, not get drawn into the fray.
So what do you think of a Biden-Harris team?
Boy, I think that would be really nice.
Whoa.
I mean,
well, she could be the bad person.
Right, politically, it would be nice. And from a electoral standpoint, it would be nice. First of all, she's from California. Now, Democrats don't have to worry about winning California. But it certainly helps a Democrat not have to campaign as much in California. Okay? She can also help in other western states where she's popular. Second, she is extremely eloquent, extremely thoughtful, has ideas of her own, most of which are similar to Biden's, but some of which are not. But then Biden didn't agree with Obama 100%. He made that clear last night.
Last night he did, yeah.
Okay, when Obama in 2008 first came out against gay marriage, Biden came out and disagreed with the person he was running with. He was ahead of that issue. So they don't have to agree. They have to be able to work together effectively. They have to truly trust each other, like each other. Okay? One of the reasons Biden was such an active vice president, which is not really common in our system, was because Obama trusted him, relied upon him, and that gave Biden a real platform. Biden used to say that after they'd be done arguing and listening in the Situation Room about something, the last voice that Obama would hear before he made a final decision was Biden's. It may have been there in the Situation Room, or it could have been in the Oval Office, but the last person he would hear from would be Biden. And I believe that. Doesn't mean he always went Biden's way, but he respected him enough to give him the last voice. George W. Bush relied heavily on Dick Cheney. Now, I don't like Dick Cheney, but that also made Dick Cheney a very active vice president. I think he relied upon him for different reasons, which I won't get into now because it'll start a lot of calls. But he was also a very active vice president. Before that, that wasn't really a common thing. You were sort of there to do the ceremonial things like the Queen does in England, and you were there in case the president died. That was your job. But in terms of, a possible Biden-Harris ticket, in addition to the policy issues, let us be blunt, the old white guy and the young African-American woman would certainly tick a lot of boxes and interest a lot of different categories of people.
She could pick up Michigan, Ohio,
Yep.
Pennsylvania.
Yep. And I tell you, look, I've never really heard of Kamala Harris until she made her announcement. And when she made her announcement, I heard her speak. I was like, wow. It was a powerful coming out party. Okay? And nothing I've heard since disabuses me of her intelligence, even though I may not agree with everything she says. But, the funny thing is, I don't have to agree, and I don't know how other people feel. I don't have to agree with every policy position a candidate has to support them. I have to trust them. I have to believe that they consider issues seriously, and from a variety of different perspectives.
Are you saying you don't trust Donald Trump?
Not with my ex-wife.
Oh, man.
I mean, I wouldn't even throw her to him.
Oh. Okay.
I mean, I don't trust him with a flea. You know.
What do you really think?
Well, I've made very clear what I think in many of these shows. And again, you folks out there, who may want to ask a lawyer or call a lawyer, you don't have to agree with me either. All you really have to do is trust me, believe I have integrity, that I'm going to look out for your best interests, and if I have different political beliefs or religious beliefs than you, my perspective is, who cares? We've got so far a topic.
I was going to say.
Way back when, before I even started my own solo practice. So I'm going back now maybe 15, 17 years ago. When sexual harassment did not exist, really, for males being sexually harassed by a female.
Never even heard of it.
Didn't accept it. Now it's very well understood because it's not a gender issue, it is a power issue. If you are in the position of power, you can sexually harass somebody. And if you are a female boss and the male subordinate relies upon you for his job, he's capable of being subject to sexual harassment. That is fairly common these days. But back 15, 17 years ago when I had a federal case in the Southern District of Florida for 2 weeks, where a Publix deli manager was being accused of sexual harassment against 2 deli employees. Oh, I had lots of news networks interested. Only if we won. Because then it was interesting because now you had female on male sexual harassment, and there was another good kicker human interest part of it. The Jewish attorney, was representing 2 men, one of whom was German and one of whom was Arab.
Whoa.
So you had the Jew representing the Arab and the German. When you're looking for a hook for a story, you know this, right?
Yes.
Isn't that a hook?
That's the ultimate, yes.
Okay, so.
If I was back in TV news again, you bet.
All right. So we had a 2-week trial, and it went very well, and U.S. Marshals, who are the ones who guard the courthouse in federal courts, the sheriffs do in state courts, the U.S. Marshals do it in federal courts. They were jockeying for position to get into the courtroom, waiting for the female deli manager's time to testify. They all wanted to hear this because part of it involved using a sausage.
Uh-oh. Okay.
And other meats.
Yeah.
Anyway, so I won't get into a long story, but we came down to a particular jury instruction that the court had to give because the 11th Circuit Court of Appeals, that was the law. Other circuits disagreed with it, which usually means the Supreme Court one day will resolve the split among the circuits. I didn't like this jury charge. I argued the dickens against it. In the end, I lost that argument, and the jury charge that the 11th Circuit had approved was the one read to the jury, and we lost. And I know we lost on that jury charge. About 6 months later, the United States Supreme Court, in a case Farragher versus Boca Raton, essentially eliminated the jury charge I didn't like and adopted the other jury charge the other circuits were using.
Could you go back?
No, the case is over.
Oh.
Now, if I had appealed, maybe. But we did not appeal that case because my clients were in no position to pay me. And, so that case was over. And, of course, I've kicked myself now for 17 years that, I was 6 months too late. But,
wow.
Farragher versus Boca Raton involved a lifeguard. And the lifeguard was a male and was being sexually harassed by a female superior. And, of course, at issue, among other things, was this jury charge. Well, they lost too. But they were represented by a big bad law firm, and they took it up on appeal. And it went its way through the 11th Circuit, and then it wound its way to the U.S. Supreme Court. And the U.S. Supreme Court found in favor of the lifeguard against the city of Boca Raton. And that is what established, folks, the framework for Title VII of the Civil Rights Act, where you have to complain to your employer if you believe you're being discriminated against or sexually harassed. Because if you don't complain, then you're not giving the employer an opportunity to do the two things that the Supreme Court says the employer must do. And that is conduct a serious investigation, and if that investigation determines that your charges have merit, to take prompt remedial action. So if the company seriously investigates and finds your charges were unwarranted, and you sue, and it turns out you prove your charges were warranted, the company still wins because they did a serious, legitimate investigation. Now, if you can prove that that investigation was not, kosher, then you could still win against the company. But the company has a defense. The employer has a defense if it follows the two requirements of the Supreme Court. Do an honest investigation and then take appropriate remedial action promptly. If you do that, you could have been sexually harassed in the worst possible way. You have no claim against your employer. Because once you complained, they did what they were supposed to do. Now, you may have a claim against the person who did it to you, especially if they touched you, because then you have battery. Or if they threatened, that's an assault. Or if they held you against a wall, that's false imprisonment. You could have a whole bunch of different claims. But you don't have a claim against the employer if the employer does what it's supposed to do. And so as a plaintiff's attorney in Title VII cases, I cannot believe how many employers won't just do those two simple things and have absolute immunity from liability. Just do it. How many of them conduct a baloney, I almost said the wrong word, investigation? How many of them find facts that support the claim, whether it's sexual harassment or race discrimination or age discrimination or national origin or whatever have you, religious discrimination, and then don't do the right thing? This is what makes a living in many respects for me and lots of other plaintiffs' attorneys that do this kind of work. If employers would do the right thing and just try to protect the employment context, the employment environment, not from being nasty or being mean or bullies, but from unlawful action, discriminatory action, sexually harassing action, retaliation. If they would just do that, we'd all go out of business that do Title VII work. But there are too many of them that are stupid, stupid, stupid. And I love it when they're really stupid. So, to go back to the point, to circle back, I don't think that anybody out there in Radio Land necessarily needs to agree with my political views or religious views or anything else. What they have to hopefully hear from this show. Some people have asked, well, why do you talk about this stuff? You're not talking about landlord-tenant law. I mean, sometimes we do. I talk about this stuff because it matters to me, because it relates to the law. And if the people listening get the impression that, gee, he sounds intelligent, or he sounds like a decent person, or he sounds like he cares, any of those things, then it doesn't matter that I wasn't talking about the subject matter that they may be interested in at that moment. They can call my office and we can deal with that. Hopefully what they hear is, this sounds like somebody that I can at least, maybe trust or get along with, or who will listen to me and, not treat me like somebody because I don't wear a three-piece suit. If anybody wears three-piece suits these days, I don't remember.
In Florida?
Not in Florida. I remember when I first started debating, my father went out and got me so many three-piece suits. But
but that was up in Jersey.
That's right. Those days have gone. So I only have a few minutes. Let me say this again, just on transgender. We never did finish it. But, the First Amendment also gives folks some rights, and it gives predominantly these students rights to say what they need to say and not be punished for it. That's the essence of the First Amendment. And if they are punished for it, then there may be a cause of action under Title IX. Another thing to look at is the Equal Access Act, completely different statute. And under the Equal Access Act, schools all the way up, from elementary through college, if they're taking federal funds, must provide equal access to, let's say, clubs and groups. So if you're going to allow the conservative Republicans of America to use a classroom, you better allow the socialists of America to do it as well. If you're going to allow the heterosexual Students for Freedom, I made that one up, then you have to allow the LGBTQ group to have access to a classroom. And that is essentially the Equal Access Act.
So what about the KKK?
Well, you know something? That is a toughie, but I know the answer. If they are not acting in violation of any other policy, the school board, violence, advocating violence, things like that.
Which they do.
But if they don't, they have a right to the classroom as well.
Whoa.
Okay?
God.
You cannot, this has nothing to do with Title IX, but you cannot refuse them access based upon the content of their speech or their opinions. I mean, that is the essence of the First Amendment. Now, once they go over the line of advocating violations of law, even civil disobedience, then you can start reasonable time, place, and manner restrictions. Certainly, this happens in these protests all the time. If the Ku Klux Klan wants to have Classroom 121, knowing that at the same time the African American Student Alliance is in Classroom 122, you can say no and put them on the other side of campus. There's nothing wrong with that. We have these protests where these antithetical groups come out because they know the other one is there. You're entitled to put them a few hundred yards away. Anyway, looks like we've run out of time. Another edition of Ask a Lawyer. I'll be back next Friday after July 4th. Hopefully you're all still here and not hungover from the fireworks. So until then, Stewart address. Hey, give Cheryl a call. I mentioned her name. 781-8003. And have a wonderful weekend. Bye-bye.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie. WPSL.com, worldwide on Alexa and Google Home.